court rejected that argument. And I think that they were entitled to reject the argument because the carrier's reviewer listed her IME report among the material that they had reviewed when reaching their conclusion that Ms. Wallace wasn't disabled from the duties of her job. So the Second Circuit noted that the regulations didn't state that a reviewing physician was required to address each document in detail before arriving at a determination, but suggested that they certainly had to acknowledge it. And the court ultimately found that Hartford had not abused its discretion and upheld the denial. So long as your IME or your rebuttal material, be it your own IME report, a functional capacity evaluation, a report from your physician, so long as that's listed in the disability carriers or plans medical peer reviewer report or IME report, it's going to be okay. And that reviewer, that liar for hire medical reviewer from the carrier or the plan, isn't required to do a little synopsis or analysis of your particular supporting medical material. They just have to acknowledge that it was something that they reviewed. And so long as they do that, they have satisfied, at least in the Second Circuit, the ERISA regulations. Now, I think it would be helpful if the disability carrier's paper reviewer discussed each report so that you actually, if they're going to reject it, you know why, and you can address that. Or if they have ignored it, you know that even though it may be listed, they didn't actually review it. In other words, just because you have listed it, I don't think that's sufficient, because I think that they should be addressing any particular or pertinent parts of your reports that they have rejected or have, basically, dissed, if you will. Because you never know if they really have reviewed it. Just because they listed it doesn't mean that they reviewed it. And more importantly, one of the things that you need to understand is that more often than not, when there is a peer review or a second level peer review, the disability carrier plan's nurse is actually sending that paper reviewer a summary of your medical records by doctor, normally by date. And that summary is based on their own subjective biased review of your medical records. In other words, it's not uncommon for the disability carrier's nurse to cherry pick your records in the summary that they give to their peer review provider to comment. So in my experience, just because the peer reviewer or their IME listed it as something that they may have seen, the reality is they, one, probably didn't see it. Two, they only saw a summary of it. And three, they have seen a cherry-picked summary of those particular medical records. So in my view, just the fact that it's listed is not really providing a full and fair review. And perhaps the court just didn't understand the realities of what happens in the peer review process. So again, a lesson learned. Ready? Let's take another break before we come back to ERISA regulations part 2.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.